Hey, everybody, welcome. Welcome to today's Law of Self-Defense show. I am, of course, attorney Andrew Branker for Law of Self-Defense. Thank you. Thank you very, very much. Come on in, make yourselves comfortable. A bit of an early show today. I do have to be in court today. I'm an expert witness in a murder trial here in Colorado, and I have to get to court early enough to hear the state's use of force expert witness. No comments on his report at this time, maybe after the trial. And then he's, of course, testifying on behalf of the state. The state goes first, presenting their case in chief. We expect the state to rest today, and then the defense will begin presenting their case in chief, and I'll be part of that. So in the meantime, there's a case in the news I did want to cover today because, well, it's in the news, in the headlines, and there's the typical kind of propaganda campaign being energized around this case that we see in these racially energized cases. How can you tell if a case is racially energized? Attorney Ben Crump is involved. That's how you can tell. That's the dead giveaway right there. This involves a shooting in Florida between a white woman shot a black woman, her neighbor, through the front door of her home, through the front door of the white woman's home. And apparently they had a lengthy, acrimonious 2.5-year bad, toxic relationship. It's amazing how many of the cases I work on are cases involving aggravated assault with a deadly weapon between neighbors. It's probably the single most common category of cases I work on. But in any case, a very toxic relationship. And because Benjamin Crump is involved, because it's a white shooter, a black victim, of course, the propaganda machine has been fully energized. The media is fully on board with Crump. And of course, the various social activist accounts on social media, particularly Twitter, I presume elsewhere as well, are out spewing their usual misinformation, disinformation on self-defense law. So I wanted to take a moment to once again clarify the lies of these racial arsonists, this racial grievance industrial complex of which Benjamin Crump is a leader. So with that, let's go ahead and jump into the intro to today's show. Here we go. All right, folks, so we're here to talk about the shooting of Ajike Owens, a black woman in a Florida community, by one of her neighbors, a white woman, Susan Lorincz. Apparently, these two women had a very toxic, acrimonious relationship for more than 2 years, and it all blew up last Friday. And we'll go through a couple of news reports of the event so we have what facts are available. I'll tell you up front that I don't have sufficient facts to be able to make anything like an informed assessment of whether this shooting might have been lawful self-defense, defense of highly defensible property, or whether it was just outright murder. So I don't have a position on the merits of the shooting. I do have a position on how the law's being communicated to the public. Because it's full of the usual disinformation and misinformation, both factual and legal, that comes with any case being racially energized by attorney Ben Crump. And that's not right, because if people, if the public's misinformed on what the legal questions are, they certainly can't understand what the correct and just legal answers are. So our job here today is just to take a look at the law as it's being communicated and explain why they're doing it wrong again, like they do every time. As I always caution, everything the mainstream media has to say about use of force law and cases has to be assumed to be wrong until proven otherwise. I would also caution that whatever we think the facts are, a lot of these facts are being provided by guys like Benjamin Crump, who of course were not there when the event went down. So anything Crump says about any of these cases, especially in a factual manner, has to be assumed to be a lie. He routinely fabricates facts about these cases, which the media is happy to amplify 10 million-fold. So these false facts become the perceived and accepted truth throughout the United States. I can tell you the same kind of lies were told about the Trayvon Martin shooting by George Zimmerman. And I lecture at the FBI Academy, and The people I'm lecturing to, senior law enforcement from all over the country, still believe those lies to be true. Because propaganda is done because it works. And Benjamin Crump has a very sophisticated propaganda machine, as well as, of course, as being abetted by the mainstream media. He's much more sophisticated about this stuff now than he was 10 years ago during the Zimmerman campaign, and he was pretty effective during the Zimmerman campaign. Why would he do this? Well, because Benjamin Crump makes a lot of money from these cases, tens of millions of dollars in settlements like that without ever having to go to court to actually win a judgment. So we'll go through some news stories. We'll go through some examples from social media about how this is being propagandized. I do, of course, am obliged to mention the sponsor of today's show, which is none other than Law of Self-Defense itself. This is an open access show, so it's streaming not just to our Law of Self-Defense members, but also on YouTube, on Rumble, and on Twitter. More than half our content is members only. In fact, just yesterday, we did a show involving a number of events using cars as deadly weapons, both by the bad guys and by the good guys. One of them was this carjacking scenario where the car was used to bump the carjacker out of the way. Another was a case in which a pulled over Ford Escalade drove off with the cop on the sideboard of the car, and the cop starts shooting the driver. And we had
push your hands up.
Whoops, sorry about that. Didn't actually mean for it to play. Another one was this guy, a cop on the hood of a car. Where is it? There's the cop on the hood of the car. And the non-compliant suspect with an outstanding warrant would eventually drive at a sufficiently high speed that the cop is hurled off the vehicle. This cop does not shoot. Look at that grip, though. Whoops. Look at that grip. Look at that grip. That's not good. And this is the cop actually on the hood as the bad guy starts driving away. Probably should have shot there. But the analysis of those kinds of cases, folks, are things that we only do for members-only shows because we get demonetized every time we actually share those on YouTube. This show will probably be demonetized just because I showed those little few seconds worth. If you'd like our legal analysis of those kinds of real-world use of force videos, pays to be a member, folks. And the good news is being a member of Law of Self-Defense is dirt cheap. You can try it out for 2 weeks for 99 cents, get unlimited access to all our members-only content during that 2-week period. And if you decide you don't like it, just ask for a refund. We'll give you 200% of your money back, so it's a negative risk opportunity. And if you stay a member, and virtually everybody does, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. And if that sounds attractive, and it darn well should, folks, you might also consider becoming a Platinum member, which is our highest level of membership. Platinum members are the only people who have access to our legal consult. If you're involved in a use of force event, we consult to your lead attorney. We're your expert witness. We're anything you need, bringing our expertise to bear on your use of force event. We don't take outside consults anymore, folks. We only do them for Platinum members, and Platinum members get that consult for free. When we took outside consults, they were a minimum of $10,000. But Platinum members get those for free. Plus, as part of this offer up on the screen, not only do you get Platinum coverage for yourself and your spouse for 5 years, we'll also send you $3,000 of all our educational courses and content that we have. Our full-day course on DVD, instant access live stream, 2 tickets to the next live version of that full-day class, one for you, one for your spouse. 3 state-specific courses, whatever 3 states you prefer. Our course on defense of property, defense against riot, looting, and arson, how to pick self-defense insurance, and much, much more. Collectively, that's all $6,000 worth of value. And we'll make it available to you instantly for 82 cents a day, folks. And you can learn more about that at lawofselfdefense.com/82 cents. And to take advantage of just the 2-week trial offer, it's lawofselfdefense.com/trial. All right. With that housekeeping out of the way, let's take a look at some of the social media commenting on this case in Florida. Here we have someone called David Roberts. I don't know who he is, but his tweet here is typical of the kind of tweeting I'm seeing on this case. He writes, Here we see the inevitable logic of stand your ground laws playing out. A white woman shot her neighbor, a black mother of 4, through the front door, but she will claim that she felt threatened, and a racist justice system will let her off. David, of course, conveniently locked his account, so he's free of any concern that I might respond to this utter idiocy. Whoops, that's not the button I meant to press. Here we have another one. A white woman in Florida has been arrested after police said she shot her black neighbor. As usual, they capitalize black, but not white. Why would that be? Is that not racist? I mean, normally we capitalize proper nouns, things we place greater value on. A white woman in Florida has been arrested after police said she shot her black neighbor, a mother of 4, through her front door in an apparent stand your ground case. So again, this is supposed to be a stand your ground case. How about this one? A racist white woman in Ocala, Florida, shot and murdered. How do we know it's murder and not self-defense? Well, we don't, except Ricky wants it to be murder. Her neighbor, a black woman named Ajike, my apologies if I'm mispronouncing that, AJ Owens, in front of her 9-year-old child, simply for knocking on her door to retrieve an iPad she took from her child. Are those true facts? She got shot simply for knocking on the door? Maybe. That could have been what happened. Maybe not. She, the white woman, has now finally been arrested. There's a lot of outrage because it took several days before the local sheriff arrested the white woman in this case, Susan Lorincz. What else have we got? Here's the sheriff. Sheriff Woods said that this was not a stand your ground case, but simply a killing. So he's arrested the white woman, charged her with manslaughter and other offenses. And it may well be manslaughter. I don't know. I don't have a robust set of facts that would point me in one direction or the other. The sheriff believes he's got probable cause to make an arrest and charge for manslaughter. But the sheriff, gratifyingly enough, recognizes that this is not a stand your ground case. There are hardly any stand your ground cases, really. Hopefully the sheriff actually knows what a stand your ground case is. It appears to be that he does, which is nice. All right, so let's take a look at some of the news reporting now, which really just continues the propagandizing you see in social media, except in higher form, louder form. So this is from June 6th, so a couple days ago, an early report. Again, this shooting happened last Friday, so a week ago tomorrow. From the Washington Post. Sorry, folks. Family calls for arrest of white woman who fatally shot black neighbor. Calls are growing for an arrest to be made in Florida after a black mother of 4 was shot and killed by her white neighbor through the neighbor's door, apparently over a dispute involving the victim's children. Now, look at this. The Washington Post apparently has adopted the practice of capitalizing both black and white. I mean, I don't know why we're capitalizing either, but if we are going to capitalize either, it seems to me we ought to be capitalizing both. So at least the Washington Post is doing that. Of course, what are proper pronouns, folks? They're things that identify, right? Like our names. So they're just, when they capitalize race like this, they're characterizing race as a key identifying characteristic. It's racist, of course. Continuing with the news story, the neighbor had reportedly thrown roller skates at the children Friday, the day of the shooting, reportedly, after which their mother knocked on the neighbor's door to confront her about harming the children. Wait, now it's a confrontation. It's not just knocking to recover an iPad. It was a confrontation. Does that have implications for whether or not this might have been a lawful use of force by the woman inside the home? She's being confronted by an angry person outside her door. Was it just knocking? Or was it an apparent attempt to enter the home? We don't know. But those are the facts that matter, as we'll see in a moment. We'll look at Florida law involving defense of highly defensible property. The neighbor allegedly fired a gun from behind the door, hitting the mother. Officials identified the victim as Ajike Owens, also known as AJ. They said the suspect was a 58-year-old white woman whom they did not identify. Well, she's identified now. It's Susan Lorincz. She's been arrested now. No charges have been filed in the case, and the county sheriff said his office could not make an arrest in the shooting until authorities determined whether the use of force had been justified under Florida's stand your ground law. Meh. First mistake. It's just self-defense law, folks. And Florida law does say that you can't arrest someone who's been involved in a use of force event until you've considered whether or not their use of force might have been lawful self-defense. Because if it appears to be lawful self-defense, that person ought not be arrested. Nobody would want to be arrested because they were attacked and merely defended themselves. Now, in the normal course of events, what Florida used to do, what every state pretty much still does, is the cops show up, you shot someone, they don't really care why you did in the moment, you're just arrested. You're arrested, you're charged, and you can tell it to the judge. And that whole process is unbelievably disruptive to a law-abiding person's life. Now they have an arrest record. Now they're facing criminal charges. Now they have to hire a costly attorney, even if it turns out it was totally lawful self-defense. So Florida law says before you can arrest someone on a use of force case, you have to make an assessment of whether it appears like it was lawful self-defense. Now, there must have been something that suggested it could have been lawful self-defense because it took several days, almost a week, for the sheriff to arrest the woman. Now, he did an investigation. He did ultimately arrest her, which suggests his investigation indicated to him this did not look like lawful self-defense, but the law does require that investigation to be done. And by the way, is this 58-year-old white woman a flight risk? She's going to run off to a country without an extradition treaty with the U.S.? She's going to go to Russia? They know who she is. They know where she lives. When they want her, they'll just go pick her up. The law states that a person can use deadly force if they reasonably believe it could prevent imminent death or great bodily harm to himself or herself or another. That's a fair enough description of Florida self-defense law. It doesn't include everything, but it hits key elements. Remember, folks, the elements of self-defense, 5 elements, up to 5 elements of self-defense. One of them is avoidance. 39 states are stand your ground states, just like Florida. They don't impose the element of avoidance in an otherwise lawful case of self-defense. The element of avoidance having to do with whether or not you have a legal duty to retreat before you can use deadly force in self-defense. And of course, in this context, the shooter was in her home, so she'd be covered not only by Florida's stand your ground law, but also by Florida's castle doctrine, which every state has. Even the duty to retreat states have a castle doctrine, which similarly relieves you of an otherwise existing legal duty to retreat if you're defending yourself against an intruder into your home or someone attempting to intrude into your home. Lawyers representing Owens' family, this is the woman who was shot, said the shooting was unjustified. Well, what do you think they're going to say? And alleged that the shooter had used racist language against Owens' children. You know, folks, we live in an era where it's so easy for some people to just say, well, they used the N-word, and therefore my beating of them, my killing of them was lawful. It's much like women who killed their significant others. Suddenly we discover that, she was a lifelong victim of abuse by that guy that she poured gasoline on and set on fire when he was asleep in bed. Are those claims true? They could be. Where's the evidence? Where's the evidence? Racial dynamics were at play, civil rights attorney Ben Crump. Hey, Ben, who is representing members of Owens' family, said in a statement calling for the alleged shooter's arrest. Some Florida Democrats also called for the woman to be charged Tuesday. Around 9 p.m. Friday, deputies received a call about a possible trespassing at a property in Ocala, Florida. That means it was the shooter calling the police, right? Because the black woman was at her front door. When the officers arrived, they found a woman suffering from a gunshot wound. They tried to save her, but she later died. The sheriff called it a tragic incident. Fair enough. Stand your ground laws have come under renewed scrutiny in the wake of the shooting of Ralph Yarl, a black teenager who was shot in Kansas City after he rang the wrong doorbell. Is that all he did, was ring the wrong doorbell? Or was he trying to open the screen door of the house? Presenting himself as someone attempting to unlawfully enter a dwelling. And forcibly. In any case, neither this shooting, folks, nor the Jarl shooting have anything to do with stand your ground. So what is stand your ground? We already said stand your ground relieves you of an otherwise existing legal duty to retreat. So a case can be a stand your ground case only if there would have been, under the facts of the case, an existing legal duty to retreat. Right? Because if the facts don't support a legal duty to retreat, then stand your ground has no role. If the facts don't support a legal duty to retreat, there's no legal duty to be relieved by stand your ground. Would there be a legal duty to retreat in this case or the Jarl case on the facts as we know them? No. The shooter's in her home. Now, it doesn't mean she was justified in shooting. She may have violated other of the elements of self-defense. But retreat's not one of them. It wouldn't apply. If Florida were a duty to retreat state, if Florida were Massachusetts or Maryland or one of the 11 duty to retreat states, there still would be no legal duty to retreat here because the shooter was inside her home. In assuming, of course, the shooting is otherwise lawful. If the shooting's otherwise lawful, then it's still not a stand your ground case because it's just an unlawful killing, as the sheriff here reported his view of this shooting. Owens' children were playing in a field next to their apartment complex when an unidentified 58-year-old woman, presumably the shooter, began yelling at them to get off her land and call them racial slurs, according to Crump's statement. Again, you can't believe anything Crump says. He makes factually false statements about these cases all the time. Child witnesses told police a dispute ensued over the children's tablet, I guess the iPad, and said the woman had thrown roller skates at the juveniles. I don't know. According to Crump, Owens' children left the area after the altercation, but accidentally left an iPad behind, which the woman took. When one of the children went to her residence to retrieve it, she threw it, hitting the boy and cracking the screen. So they had the iPad. It was just apparently reportedly damaged. So the victim here, the black woman, Owens, was not going to the old woman's house to recover a seized iPad. They had the iPad. The police did not confirm that the woman had thrown an iPad, so we don't know. This is all myth. Woods, who was shot, when asked... No, Woods is the sheriff. Sorry. Woods is the sheriff. The victim here is Owens. Sheriff Woods, when asked Monday about parts of Crump's statement, said he could not yet confirm or deny the allegations. Well, of course not. Including what was thrown by the neighbor and whether it was directly at the children. Right, the old woman could have found their kids' toys on her property and just tossed them over the property line. That doesn't mean she's hurling them at the kids. This is the kind of misrepresentation that Benjamin Crump engages in all the time. Having heard about the dispute, Owens, the woman shot here, went to confront her neighbor about striking a child with a pair of skates. A witness told police. People at the scene told police that the woman shot had begun knocking on her neighbor's door when a weapon was fired from within the home. Bullets went through the front door and hit Owens. Is it difficult for anybody to imagine that maybe the woman who was shot was not politely knocking on the door? Maybe she believed that her child had been assaulted and she was angry and banging on that door? Is that possible? Might that be the narrative we hear from the shooter here? That the shooter feared that this angry woman outside her door was trying to get into her house for purposes of committing acts of violence? I don't know, but that's the correct legal question that certainly Benjamin Crump's not asking. After being shot, the woman staggered back, collapsed beneath a tree, calling 911. When police arrived, they gathered around her, tried to give medical aid. They began screaming that the shooter was inside the residence. The shooter stayed inside her house until police arrived and took her into custody. She has not been arrested, but could be charged with homicide. They mean a killing crime. Homicides are not necessarily crimes, right? Self-defense, a lawful self-defense killing is a homicide, but it's not a crime. The homicide would typically be some degree of murder or manslaughter. Owen's mother, the woman who was shot, her mother said in an interview, well, she doesn't know what happened. So her daughter did what any parent would do in confronting the neighbor. She simply knocked on the door. Is that what any parent would do in confronting a neighbor who caused injury to their child? Or might she be more angry than that? She simply knocked on the door. Was the mother present to observe this? Was she a personal witness? The woman shot her through the closed door with her son, 9 years old, standing next to her. The victim was unarmed. The sheriff's office said this had not been confirmed. The sheriff, citing information about the alleged shooter, said there was a lot of aggressiveness at the door from both neighbors. Oh, wait a minute. Whether it be banging on the doors, banging on the walls, and threats being made. Well, that sounds different. We're hearing quite a different narrative from the sheriff than we are from the mother of the woman shot and her legal representative, Benjamin Crump. Might this kind of conduct create in the woman inside the home a reasonable perception that her home was about to be invaded by this angry person? I don't think it was the homeowner banging on doors, banging on walls. Why would she bang on her own door and her own walls, making threats? I think it was the woman who was shot doing those things. I don't know, but that seems the most likely scenario. Friday's incident appeared to have been tied to a neighborhood feud over time. Let's see. Florida State Senator Chevron Jones, Democrat, argued that the case showed it was long past time to repeal the state's stand your ground law. Why? This is not a stand your ground case. Stand your ground has nothing to do with the facts of this case. There would have been no legal duty for the shooter to retreat before defending herself in an otherwise lawful case of self-defense, even if Florida were a duty to retreat state, and stand your ground did not exist in Florida law. The senator goes on, quote, if the shooter feared for her life as she hid within her home, then she should have called the police. Instead, she decided to fire her weapon through the door, killing AJ in front of her children. This is nothing short of murder, and the shooter should be charged as such. Maybe it is murder. Maybe it's defense of highly defensible property. The sheriff's office said the investigation had been delayed because, a couple of Owens' kids who witnessed the shooting could not be interviewed because of the trauma. The sheriff says a lot of the rumors and questions out there have been that we're not doing anything. We're not moving fast enough because we want to seek justice and we want to ensure that we get the facts right, especially in a case to this level. We just don't take always one side because it doesn't always paint the full picture. Reasonable enough, Sheriff. Police collected 2 firearms, bullets, and other evidence at the scene, the report showed. Wait a minute. There were 2 firearms? What's that mean? Was one of them inside the house and one of them outside the house? Did one of them belong to the woman who was shot? Did she go to this woman's house and bang on her walls and doors, have an angry confrontation with a gun in her hand? Is it possible that's why she got shot by the woman inside the home? Or did the woman inside the home have a gun in each hand, like an old Western? Does that seem likely? It's possible she had a gun in hand and a gun elsewhere in the house and that was seized too, but it seems to me like it would be useful to know whether or not both guns were seized from inside the house. In the past 2 years, sheriff's deputies have received 6 to 8 calls relating to the property where Friday's shootings took place. Made by who? Who was calling the police? Was it the homeowner who fired the shot? Or was it the woman who got shot? Would that make a difference, perhaps, in who had a reasonable perception of fear that they were calling repeatedly for police assistance? But we're not given that information, are we? Why not? Why not? I'm always suspicious when the facts are hidden, that the facts are being hidden because they're not consistent with the narrative that Benjamin Crump wants propagated. That's been my experience. I wish our shooter would have called us instead of taking actions into her own hands. I wish, this is the sheriff speaking, I wish Mrs. Owens would have called us in hopes we could have never got to the point in which we are here today. Sure, I mean, you always wish that it hadn't come to violence, but that's not the question now. It did come to violence. Who was the aggressor? Who was the defender? That's the relevant question now. Generally speaking, if you're lawfully defending yourself against an imminent deadly force threat, there is no time to call the police. There's no time. Imminence being another of the elements of self-defense, that the threat you're defending yourself isn't some past threat. It's not some speculative future threat. It's a threat actually in progress or immediately about to happen. There's no time to call the police if that's the fact. All right, so that's that first news story. Let's take a look now at this one. This is from yesterday. A lot of this will be repetitive information, so I'll skip over those portions of it. White woman who shot black neighbor through door is arrested. A white woman accused of shooting and killing her black neighbor over a dispute over the neighbor's children has been arrested. She was charged. Susan Lorincz was charged Tuesday with manslaughter with a firearm, culpable negligence, battery, and 2 counts of assault. So I haven't seen the charging document, so I'm not sure exactly what form of manslaughter they're charging here. It could be heat of passion manslaughter, so a deliberate killing, but under adequate provocation. The provocation of the confrontation between the two women would mitigate murder down to manslaughter. It could be reckless manslaughter, where there was not an intent to cause harm, but the shooter engaged in an unjustified risk, knowingly engaged in an unjustified risk of deadly force harm, and death resulted. This is the Alec Baldwin scenario. It may be that the woman told the sheriff, for example, that I never meant to fire the gun. It just went off. But when it just went off, she had it pointed at the woman. That would be a reckless manslaughter. Again, just like the Alec Baldwin case. Battery and 2 counts of assault. So the battery would be the impact of the bullet on the victim here. That would be a duplicative charge. So you wouldn't be convicted of both manslaughter and battery. It would be one or the other. And 2 counts of assault. I guess the woman who was shot had a couple of her kids with her, or they observed it. Maybe they were put in fear of being shot too. Those would be the 2 counts of assault, probably. Or it could be the woman who was shot. I guess her 9-year-old was with her, so maybe both of them were put in fear of being shot. That would be the 2 counts of assault. I look forward to the charging document. The justice we have all been seeking has been served, said Sheriff Woods in an interview. The arrest came amid growing pressure. Attorneys representing the family called this an unjustified killing. Again, that would be Benjamin Crump. Again, a lot of these facts are repetitive from what we already heard. Following a major crimes unit investigation, which included interviews with Owens' children and other witnesses and uncovered surveillance footage. Was there a Ring doorbell camera? Wouldn't that be interesting to see? The demeanor of Owens at this woman's door? Why don't we have that? Why isn't that released? Is it inconsistent with Benjamin Crump's narrative of a racially motivated murder here? Uncovered surveillance footage and other forensic and digital evidence. Detectives concluded that over a period of time, the homeowner had become angry at Owens' children who were playing in a field close to her home. The detectives found that the homeowner had used racial slurs and racial language towards children playing in the field at previous occasions. That includes Owens' children, but could also be broader and include other children. So, of course, evidence is not proof, right? There were claims that George Zimmerman was a racist who used racial slurs. Claims. There was never any evidence of that. And believe me, if there had been, it would have been all over the news and all over the trial. So just because racial slurs are being claimed doesn't mean it ever happened. Where's the evidence? However, detectives investigating the case couldn't determine whether Lorincz had used racial language towards Owens' children directly before Friday's shooting. That kind of waters down that accusation. On Friday night, according to documents in the sheriff's office, Lorincz engaged in an argument with the children. A neighbor overheard her yelling at them. She threw a roller skate at Owens' 10-year-old son, maybe towards him, that hit him in the toe. She also swung at Owens' son and his brother with an umbrella when they attempted to speak to her. So she was in her house when this happened. When the children notified their mother, Owens approached Lorincz' home, knocked on the door multiple times, and demanded that Lorincz come outside. Why would you have to come outside? You can talk through the door. For a beating? Is that what was happening? Is that what Owens was proposing? Come out here so I can beat your ass? Lorincz then fired one shot through the door, or I'll come in, Come out here so I can beat your ass, or I'll come in and beat your ass. Is that's one is on the Ring footage? The Ring doorbell camera footage? Maybe. I don't know. Weird that we don't have it, though. I suspect that if the Ring doorbell footage showed Owens calmly knocking on the door saying, hey, I'd like to talk to you about what's going on with my kids and how you treat them, and she got shot for that, we'd have that video footage. Lorincz then fired one shot through the door, striking Owens in her upper chest, adding that Owens was fatally shot with her 10-year-old son standing beside her. Okay, I thought it was 9 years old, but whatever. Lorincz told investigators that she and Owens had a history of animosity and claimed that Owens had previously attacked her. Would that be relevant to a defender's reasonable perception of harm at the hands of an aggressor, that they'd previously been attacked by that aggressor? By the way, again, why don't we know who made all those prior phone calls to the police about this acrimonious relationship? Why don't we know who that was? Who called? The homeowner or Owens? The homeowner said she acted in self-defense in shooting Owens, and that Owens had been trying to break down her door. Does that change the narrative here? Now, again, we don't know if this is true, but is this the right question? In defense of highly defensible property, does it matter if the person you shot was trying to break down your door? I wonder if the Ring doorbell camera footage, if that's what it is, indicates that. Sheriff Woods previously said that before making an arrest in this case, his office had to determine whether the shooter's response was justified under Florida's stand your ground law. It's just justified under self-defense law, folks. Florida had a self-defense law long before it had a stand your ground law, which states that a person can use deadly force if they reasonably believe it could prevent imminent death or great bodily harm to himself or herself or another. That's just a statement of Florida's self-defense law. Following their investigation, detectives were able to establish that the homeowner's actions were not justifiable under Florida law to their satisfaction. So the sheriff's office believes they have probable cause to make an arrest and levy these charges against the homeowner. The homeowner is expected to make her first appearance at the Marion County Court Thursday. That would be today. Right now, she's under custody with deputies being medically cleared before we place her in a cell at Marion County Jail. She claimed she was having a medical episode. Could well be the case, 58 years old. Attorneys representing Owens' family, that's Benjamin Crump, said in a statement they were relieved to learn of their arrest, but argued it took too long and blamed the delays on archaic laws like stand your ground. Is it archaic? Is it wrong for the police to have to at least look into whether or not your use of force might have been self-defense before they arrest you and put you in jail? Is that wrong? Would Benjamin Crump want that courtesy if he was attacked and had to defend himself? If his wife and children were attacked and had to defend themselves? He just wants them instantly thrown in jail, even if what they did was perfectly lawful self-defense? This is typical Crump propaganda misinformation here. What does it say when a person can shoot and kill an unarmed mother in the presence of her young children and not be immediately taken into custody, questioned, then charged? What does critical thinking require here, folks? Considering the alternative narrative, right? The adversarial narrative. What does it say when a person can defend themselves against a violent aggressor attempting to forcibly enter their home, threatening death or great bodily harm, that when that homeowner defends themselves against that threat, they're thrown in jail immediately without any consideration of whether it was self-defense, right? That's the alternative question. Then the state's attorney left to speak to protesters. The state's attorney, he's a politician, of course. The sheriff Wood said the laws in Florida are clear. Rushing in to make an arrest is not the right thing to do sometimes. Yeah, why would it be? In fact, it can probably cause complications or cause errors. Sheriff Woods described Florida's stand your ground law as a great law designed to help Floridians to defend themselves and keep themselves safe. I would concur with that. Remember, folks, all stand your ground does, the only thing it does is remove the element of avoidance in an otherwise lawful case of self-defense. The other requirements of self-defense, the other 4 elements of self-defense are still required. Innocence, imminence, proportionality, and reasonableness are still required. So because they're required for your use of force to have been lawful, You need to have been the non-aggressor, victim of an unlawful attack that's actually taking place or immediately about to happen. If you're using deadly force to defend yourself, that attack must have been one that threatened you with death or serious bodily injury, or threatened another with that harm. And your perceptions, your decisions, your actions were all those of a reasonable person, not an irrational person. If all that's true, you're the innocent victim of an imminent, unlawful, deadly force attack, reasonably perceived as such. Why should you have a legal duty to try to retreat before you can defend yourself against that attack? All right. Let's see. This story is from CBS News, but I think, all these news stories tend to be the same because they all follow each other's. They're basically copying each other. Let's see. They have video of the woman being arrested. So they did a perp walk on Facebook. That's always nice. Thanks, Sheriff. The sheriff said this was not a stand your ground case, but simply a killing. Well, certainly not a stand your ground case. May have just been simply a killing. Of course, not all killings are unlawful. The sheriff says, now many of you were struggling to understand why there was not an immediate arrest. The laws here in the state of Florida are clear. I may not like them. I may not agree with them, but those are the laws I will follow. Again, sheriffs are also elected positions. So he's a politician, Sheriff Woods. Most of these facts, let's see, are the same. We've already covered. Owens approached the homeowner's house, knocked on the door multiple times, demanded that the homeowner come outside. Lorincz then fired one shot through the door. This is not simply a knocking on the door. Deputies responding to a trespassing call at the apartment Friday. So that would not obviously have been the shooting reporting trespassing. The only person who would have been trespassing would be her. She's not calling to report herself as trespassing. That would have been the homeowner calling the police. Why don't they say that? The sheriff's office knows who made the trespassing call to the police. When questioned by the sheriff's office, the homeowner claimed she acted in self-defense and that Owens was trying to break down her door. The homeowner also claimed that Owens had come after her in the past and had previously attacked her. Highly relevant claims, folks. Highly relevant evidence. May not be true. I don't know. I'd have to see the actual evidence. But these are the right questions. Was there an apparent attempt to break down the homeowner's door? Were there previous attacks by Owens on the homeowner? Those are the right questions. The manslaughter charge the homeowner is facing is punishable by up to 30 years in prison. She's also charged with culpable negligence, battery, 2 counts of assault. Let's see what else. Then we have the civil rights attorney, Benjamin Crump, who's representing Owens' family, said in a statement that the shooter had been yelling racial slurs at the children before the confrontation. He also represented Trayvon Martin's family in 2012, in which he lied relentlessly and unashamedly about that case, and still does to this day. The sheriff's office hasn't confirmed that there were slurs uttered or said whether race was a factor in the shooting. So I guess the evidence isn't uncontrovertible, is it, Ben? Let's see. Woods said on Monday that detectives were working with the state attorney's office and had to investigate possible self-defense claims before they could move forward with any possible criminal charges. Obviously, they've done that now, and I think that's a good policy. Let's see. Lawrence Smith, who lives across the street from where the shooting happened, said the homeowner was angry all the time with the children. Well, we know the mother was angry, right? The woman shot. We know she was angry at the moment of the confrontation. Or at least there's evidence to support that. The sheriff said since January 2021, deputies responded to at least a half dozen calls in connection with the feuding between Owens and the homeowner. Who made those calls? There was a lot of aggressiveness from both of them back and forth, whether it be banging on the doors, banging on the walls, and the threats being made. And then at that moment is when Miss Owens was shot through the door. Again, are we to believe the homeowner was banging on her own doors and walls? We know there's evidence that the woman shot was demanding the homeowner come outside. Why? To have a pleasant conversation? I'm heartbroken, said moms demand action. We've seen this again and again across the country. It's really because of lax gun laws and a culture of shoot first. Of course, that's just anti-gun propaganda, anti-civil rights propaganda, anti-Second Amendment propaganda. This woman with the hyphenated name, executive director of Moms Demand Action, said stand your ground cases, which she refers to as shoot first laws, are deemed justifiable 5 times more frequently when a white shooter kills a black victim. That's just a lie. That's an outright lie. Whenever I ask these people for data to support that claim, they either don't provide it or the data they provide are not stand your ground cases. They're just shootings involving people of disparate race. They may be shootings that involve self-defense immunity hearings, but those are not stand your ground cases. And in any case, just because there's a statistical variation doesn't mean it's an injustice. For example, almost 60% of violent crime in America is committed by the 5% of the population that is young black men. There's a disparity for you. In 2017, Florida lawmakers updated the state's self-defense statute to shift the burden of proof from a person claiming self-defense to prosecutors. This means authorities have to rule out self-defense before bringing charges. Okay, this is just a hot mess of just wrong information. Probably not deliberately wrong, but journalists tend to be pretty stupid people. They're just getting it wrong. So the burden of proof on self-defense has always been on the state in Florida. It's on the state in every state now. Ohio was the last holdout that put the burden of proof on self-defense on the defendants. But once you're at trial, the burden of proof on self-defense is on the state to disprove self-defense beyond a reasonable doubt. Period. Now, before the trial, if someone charged with a use of force crime is seeking self-defense immunity, demands a pre-trial self-defense immunity hearing, there, the burden of proof in Florida used to be on the defense to prove self-defense in that hearing, to get immunity by a preponderance of the evidence. But in 2017, the Florida legislature said, no, we don't like how this is working because nobody was being granted immunity by these hearing judges. The Florida legislature said, no, the way the trial judges, the hearing judges are dealing with these cases, no one's getting immunity. That makes the self-defense immunity statute meaningless. So we're going to change the burden of proof on self-defense immunity, not self-defense at trial, which was already on the state to disprove self-defense beyond a reasonable doubt. We're going to put the burden on the pre-trial self-defense immunity hearing also on the state by clear and convincing evidence, which is evidence that's more than a preponderance, but less than beyond a reasonable doubt. So that shift did occur. When they say that means authorities have to rule out self-defense before bringing charges, that was already the law before this shift in burden happened in 2017. Before the change in law, prosecutors could charge someone with a shooting, and then defense attorneys would have to present an affirmative defense for why their client shouldn't be convicted. Right? Why should this be the standard? If it's a clear case of self-defense, shouldn't the cops have to at least consider the possibility that it was self-defense before they run this person's life through the gears of the criminal justice system? Just consider it. Take a look. Could it have been self-defense? That person shouldn't be arrested and required to hire an attorney at great expense to raise a legal defense. The article continues. In fact, stand your ground and castle doctrine cases, which allow residents to defend themselves either by law or court precedent when threatened, has sparked outrage amid a spate of shootings across the country. Well, outrage is just means propaganda, right? That's Benjamin Crump. He's looking to get another big paycheck. All stand your ground and castle doctrine do is relieve you of that element of avoidance, relieve you of an otherwise existing legal duty to retreat. This phrase is so weird, but this is the kind of mental incapacity of most journalists, which allow residents to defend themselves either by law or court precedent. Well, court precedent is law. Law comes in two forms, right? Statutes by the legislature, and then when those statutes are interpreted and applied by appellate courts, those appellate courts establish precedent. That's just as valid law as the statute. And what difference does it make whether the law outlining your privilege to use force in self-defense comes from statute or comes from precedent, appellate court decisions. Most states have self-defense statutes, defense of other statutes, defense of dwelling statutes, all that. Some states don't. Massachusetts has no self-defense statutes, except for Castle Doctrine. But Massachusetts self-defense law is entirely in precedent, entirely in appellate court decisions. That doesn't make it less valid than if it were in statute. Then they talk about the Ralph Yarl shooting, not really relevant here. Missouri and Florida are among about 30 states that have stand your ground laws. 39 states, folks. 39 states are stand your ground states, either by statute or by precedent. The most well-known, excuse me, the most well-known examples of the stand your ground argument came up in the trial of George Zimmerman, who fatally shot Trayvon Martin. Was stand your ground ever argued in the George Zimmerman trial? No, not in any form. Not in the proper application of stand your ground, whether or not there was a legal duty to retreat. There was no legal duty to retreat anyway. In the Zimmerman case, he'd been struck to the ground. Trayvon Martin was mounted atop him, beating him into the sidewalk. Per eyewitness testimony, you're undergoing the imminent deadly force attack. There is no chance of retreating when you've been pinned to the ground. There is no safe avenue of retreat. And if there's no safe avenue of retreat, there is no legal duty to retreat. Even in a state that's a duty to retreat state, even in those states, the Massachusetts, the Maryland, you're only required to retreat. You only have that legal duty if it's possible to do so with complete safety. If you're pinned to the ground and getting your head beat into a sidewalk, there's no opportunity to retreat with complete safety. So Zimmerman would have had no legal duty to retreat on the facts of that case, and therefore there's no role for stand your ground to relieve him of a legal duty he doesn't have. Now, of course, often journalists and others misuse the phrase stand your ground to actually mean self-defense immunity. That's an error. That's sloppy thinking, sloppy labeling, leads to confusion. But let's pretend that's what they mean here. Did Zimmerman ever pursue self-defense immunity? No, that never happened either. So there's no form in which the Zimmerman case involved stand your ground at all. Why do people believe it did? Because of Benjamin Crump's propaganda campaign. Before, whoops, what happened? I lost my, here it goes. Before trial, Zimmerman's attorneys chose not to pursue a stand your ground claim. They mean a self-defense immunity claim, which could have resulted in the dismissal of murder charges, as well as immunity from prosecution. Those are the same things. If you're immunized from prosecution, the charges go away. But during the trial, the law was essentially used as part of his self-defense argument. No, it wasn't. No, it wasn't. His self-defense argument was straight up self-defense. Had nothing to do with either stand your ground or self-defense immunity. I watched every minute of that trial, and neither of his lawyers, Don West nor Mark O'Mara, ever made reference to stand your ground or self-defense immunity in any substantive way. They may have said something along the lines of, the judge will instruct you that stand your ground doesn't play a role in this case. They certainly never argued it on behalf of their client. And last, this article from today. There's Benjamin Crump right there in the middle with the power fist, the angry power fist going on. Justice for AJ. For Benjamin Crump, it's only justice when his side wins. For him, justice is an outcome, not a process. For right-thinking people who care about actual justice, not racial justice or other prefix justice. Anytime you put a prefix in the word justice, folks, you mean something quite different than justice. Justice is process-based, correctly understood. We all agree on the process. The process applies to everybody. And then we have different outcomes. But the process, if we believe it's fair and fairly applied to similarly situated people in the same way, then we accept the outcome even if we don't like it. If the process is corrupt, then you can't trust the outcome. You have no faith and confidence in the outcome. That's not justice. Let's see. In less than a decade, the Florida-based attorney Benjamin Crump has become the voice for the families of Trayvon Martin, whose killing was lawful. Michael Brown, hands up, don't shoot. His killing was lawful. Breonna Taylor, tragic. Her killing was lawful. George Floyd. Well, there was never any intent to kill George Floyd. No one claimed that. And Tyree Nichols. Can't even remember what Tyree Nichols was about. Someone will have to refresh my recollection. Was that the doorbell shooting in New York? I think so. So we don't even know then whether or not that was a lawful shooting or not. Benjamin Crump has won multi-million-dollar settlements. He gets 30 to 40% of those, folks. Never has to go to trial. They're all settlements. So he doesn't go to trial to argue these cases in front of a jury. Why does he get settlements? Because most of these settlements are being paid by people who are happy to spend other people's money, taxpayers' money, to make their political problems go away. Or it's being paid by an insurance company that doesn't want the political heat. So they're happy to spend money to make their political problems go away. Let's see. This is just an ode to Benjamin Crump, I guess. This week, he's standing with the family of Ajike Owens, a black woman fatally shot after going to the apartment of her white neighbor. That's all she did. She just went to the apartment of her white neighbor. That's why she got shot. What happened to the banging on walls, banging on doors, demanding the neighbor come outside? The prior attacks of Owens on the neighbor. The many calls to the police prior to this incident. By who? We don't know. We don't know because they won't tell us. Why won't they tell us? Let's see. He's now quoting Al Sharpton, another racial arsonist, of course. Sharpton says he's a real believer, Benjamin Crump, in what he's doing. Well, it's very profitable. Crump gets tens of millions of dollars each time he makes one of these $30, $40 million settlements. He has taken the attacks. He has taken the cases that others wouldn't take. What? People can go to him. The reason I trust him is because he's never misled me. Benjamin Crump lies about these cases continuously, but then again, so does Al Sharpton. So they're telling the same lies. I guess that's what Al Sharpton means here. These days, Crump seems to be everywhere. A Florida law school now bears his name. Oh, good Lord. I didn't know that. Jeepers. What a world. What a world. A law school named themselves after a racial arsonist and propagandist. Amazing. I wonder what kind of students are graduating from that law school. I wonder what the bar passage rate is. Of course, he was involved in Floyd. Critics see Benjamin Crump as an opportunist who never fails to show up amid another tragedy. Sure, fair enough. But those who know Crump says he's been fighting for fairness and his wallet long before his name was in headlines. When there's an injustice, that's where he wants to be. Really. Crump 51 is a tireless worker who mixes Southern charm, a talent for attracting media attention, that just means propaganda, to his cases, and a firm belief that racism afflicts the nation. Sure, racism is the lever by which he fattens his wallet. And the courts are the place to take it on. He doesn't go to court, folks. He doesn't go to court. These are all settlements. This is all, a love letter to Crump. So I'm going to skip over all of this. Oh, just an example. In March of 2021, the city of Minneapolis agreed to pay $27 million to settle a civil lawsuit from George Floyd's family. So Crump would have gotten something like 40% of that. So $8 million. Ka-ching. Easy peasy, lemon squeezy. All right. So that's where we are with all of that. Now let's take a quick look at Florida law on defense of highly defensible property. So these PowerPoint slides are taken directly from our Florida state-specific supplement. So we do a full day course on use of force law. We call it our advanced class. It's 6-7 hours in length. We teach it live once or twice a year. But of course, we also make it available as a DVD, as online streamed format. But it's covers all 50 states. So it's kind of generic in that sense. Where there are variances in the states, we do point those out. But the full day course is not state specific, so we supplement that with state specific supplements. We have separate supplements for each of the 50 states. This is the one we have for Florida. Florida's, and this is section 9 of that course, the defense of property course. So I'm not going to go through all these slides here, but we do distinguish defense of property between least defensible property, which is just personal property. Under Florida law, only non-deadly force to defend personal property at best, and highly defensible property like your home. And you may be privileged to use deadly force in defense of highly defensible property. So let's take a look. Here's just the defense of property statute. You can use force or threaten to use force except deadly force to stop simple trespass, criminal interference with property, personal property in your possession. This is just defense of simple personal property, non-deadly force only. But it has to be your property in your possession or that of a member of the family or property you have a duty to protect, like you're a loss prevention officer in a store, for example. But you're only justified in using deadly force in the context of defense of property if you're stopping a forcible felony. Well, a forcible felony is a threat of force against a person. So we're really now talking about a defense of persons scenario. Here are forcible felonies: treason, murder, manslaughter, sexual battery, carjacking, home invasion, robbery. You can see these are all actually acts of violence against a person. Then we have so that was statute 776.08. Sorry, that's the forcible felony definition. Defense of just personal property, 776.031. Defense of your home is a different statute because different legal doctrines apply. 776.013. Home protection, use of deadly force. Defense of your dwelling. What does dwelling mean? Dwelling means a building or conveyance of any kind, including any attached porch. That means this homeowner, if the woman she shot Owens was on her porch, it's treated as if the woman were inside her home for purposes of the definition of dwelling. Residence, vehicle, those aren't particularly relevant here. Don't add much here. Justifiable use of deadly force, yet another statute, 782.02. The use of deadly force is justifiable when a person is resisting any attempt to murder such person or to commit any felony upon him or her or upon or in any dwelling house. Is aggravated battery a threat of aggravated battery, attempted aggravated battery, grave bodily harm caused in the course of a battery? Is that a felony? Yes, of course. Would a 58-year-old woman be exceptionally vulnerable to injury, to great bodily harm in a manner that a 25-year-old man would not be? Sure. Here's the relevant jury instruction. It says the same thing as the statute, so I won't bother reading it. And then we have the defense of highly defensible property, special legal provision. This is common in many states. If you're defending yourself in your home against an unlawful enforceable intruder, a legal presumption is created that you had a reasonable fear of imminent death or great bodily harm. Folks, that gives you 3 of the 5 elements of self-defense right there. It's legally presumed that you had a reasonableness, fear of imminent, that's eminence, peril of death or great bodily harm. That's proportionality. That's 3 of the 5 elements of self-defense right there. You also don't have avoidance here because Florida stands your ground, but also because you're in your castle, you'd be relieved of avoidance anyway, even if Florida was not a stand your ground state under the castle doctrine. So that's 4 of the 5 elements needed to justify the use of deadly defensive force. The only one left is innocence. And innocence is rather baked into the cake. If you're in your home dealing with someone attempting to forcibly and unlawfully enter your home. So let's take a look at this provision in more detail. 776.013, home protection. A person is presumed, legally presumed, to have held a reasonable fear of imminent peril of death or great bodily harm to herself when using or threatening to use defensive force that is intended or likely to cause death or grave bodily harm to another if the conditions of the statute are met. So what are the conditions of the statute? The person against whom the defensive force was used was in the process of unlawfully and forcefully entering a dwelling. Is that what was happening here? Remember, the state would have to disprove beyond any reasonable doubt that Owens, the woman shot, was attempting, they have to disprove that she was attempting to unlawfully and forcibly enter the homeowner's home here. Remember the banging on the doors, the banging on the walls? Could there be even just a reasonable doubt that Owens was attempting to unlawfully and forcibly enter the home? And also required the person who uses or threatens defensive force had reason to believe that an unlawful and forcible entry was occurring or had occurred. Well, the homeowner would be observing that here. Then there are exclusions to this presumption, but I don't believe any of them would be triggered here. One of them is that the person against whom the force is used had a right to be in the dwelling. That's not the case. That it involves a removal of a child from the dwelling. That exclusion doesn't apply. That the homeowner here was engaged in some other criminal activity. There's no evidence of that. Or that the person against whom the force was used was a law enforcement officer. Nope, that's not the case here. By the way, there's another legal presumption. A second legal presumption atop the one we just described that gave the elements of self-defense to the defender. There's a legal presumption about the person entering unlawfully and forcibly. The same statute, different paragraph. A person who unlawfully and by force enters or attempts to enter a person's dwelling is presumed to be doing so with the intent to commit an unlawful act involving force or violence. This is a presumption that applies to Owens. If she was unlawfully and by force attempting to enter this woman's homeowner's dwelling, Owens is legally presumed to be doing so with the intent to commit an unlawful act involving force or violence. In other words, a forcible felony, an independent justification other than defense of home to use deadly force in self-defense. And there's the jury instructions on making the same argument. By the way, the last time I checked, so most of these legal presumptions of a reasonable fear that I've been talking about, in most states, they're rebuttable. In other words, the state may have other evidence that's contrary to the presumption. Maybe the homeowner had stated to a friend that she intended to orchestrate a killing, for example. But the appellate courts of Florida have said, no, if the jury finds that the conditions of the presumption have been met, it's unrebuttable. It's an irrebuttable presumption. Cannot be rebutted by the state, by the prosecution. Here's that decision. The creation of 776-013, the home defense statute we were just looking at, eliminated the burden of proving that the defender had a reasonable belief that deadly force was necessary by providing a conclusive presumption of that reasonable fear of imminent deadly force harm. State v. Heckman, Florida, Court of Appeals, 2007. All right, folks. I have to get down to Colorado Springs to do my expert witness testimony. But how do I stop this? There we go. All right. But I will take an opportunity to look at questions. By the way, our new policy currently in effect is that we only take questions from our Law Self-Defense members in the Law Self-Defense member chat. So we don't look at YouTube comments, not even super chats. We don't look at Rumble comments, not even super chats. If you want to make a comment or ask a question and have me address it, we only take those from Law Self-Defense members on the member chat in, whoops. There we go. And as previously mentioned, you can become a Law Self-Defense member. You can do it instantly right now for only 99 cents for 2 weeks. 99 cents for 2 weeks, folks. Unlimited access to all our members only content. lawofselfdefense.com/trial. 99 cents, folks. And if you stay a member, and virtually everybody does, It's still dirt cheap. It's only about 30 cents a day. It's less than $10 a month to be a law self-defense member. And those are the only folks that we take questions from. All right. So many buttons. I know. I'm so sorry, folks. You're paying, if you are paying, for legal expertise, not production value. All right, let me take a look at the questions from the members. Richard says, screaming harpy, ready to do violence, as is typical from the times I have observed in the past. That may be the facts that are developed here, right? Certainly, I expect that's what the defense to say. Miles Dog says, I'll just smile psychotically until they cross the threshold into my house. That would certainly remove ambiguity. Let's see. Kyle says, agreed. I remember my own parents in my adulthood where if you had a gripe, you went to the person politely and tried to reason it out. There's so much entitlement these days. It seems like it's a mark of valor to start tearing into and threatening the person. Some people have poor emotional control. No question about that. Richard says, in my mind, I can see the scene based off of seeing incidences in the past. Yes, right? I mean, we don't know if that's what happened here, but we've certainly seen that kind of thing happen before. Kyle says, question, is there any history with the victim that would add to the anxiety of the shooter? Seeding the fear of imminent harm to the defender. Well, the news reports we looked at said that the defender claimed she previously had been attacked by Owens. Richard, I can be certain that the pressure to charge was immense. Yeah, once Crump is involved, the pressure's at 11. Let's see. Yeah, Chuck asks, I wonder what Crump thinks about Travis Rudolph. He doesn't think anything. There's no racial lever to pull there. Let's see. Miles asks, question, aren't appellate rulings more valid than mere legislative statutes? Well, it's kind of a subtle question, Miles. So in one sense, yes, right? In the sense, well, let me reverse that. In one sense, no. The courts are supposed to be bound by the plain reading of the statute. And if the courts would prefer a different outcome or a different interpretation inconsistent with the statutory interpretation, the courts are supposed to go, look, nothing I can do. The legislature makes the laws. I'm bound by the laws. That's what the courts are supposed to do. Now, invariably, of course, there's almost always some requirement to interpret statutes to the particular facts of a case. And what sometimes happens is the courts will interpret expansively, read whole words in and out of statutes that profoundly change the meaning of the statute. And now it is that appellate court's interpretation of the statute that controls. Is that legislating from the bench? Is that simply engaging in necessary interpretation of statutory language to real world cases? I mean, I think it's all those things, depending on how and when it's done, for sure. Paul says, I can't take this BS about Crump. He, Jesse, and Al are just race baiters. Yep, I concur. I call them racial arsonists. Terrible. Richard, where there's potentially extortion to be had, that's where he wants to be. Yep. Miles, you answered my porch curtilage question before I could type it, but unless I see a weapon, I'll just psychotically smile and wait, go away. Yeah, me too. All right, game time. Do your LOSD thing in court. Don't burn the prosecution expert too much. Yeah, I don't want to talk about the prosecution expert's position, use of force position at this time because the trial's still in play. If I'm free to, I'll be happy to talk about it at a later time. I'll have to explore that with lead counsel on the case, but it's yeah. Okay. So, folks, thank you. Thank you so much for joining all of me again today. I can't do any of this without your support, of course. Can't tell you how much I appreciate it. Again, don't forget, you can become a Law Self-Defense member, 99 cents, 2 weeks, unlimited access, lawselfdefense.com/trial for trial membership. Stay a member. It's only about 30 cents a day, less than $10 a month. Or, as we have here in the bottom of the screen, bump up to be a platinum member. Get my legal consult on your use of force case for free, folks. No $10,000 retainer like we used to do. But we only provide those legal consults to our platinum members. Get 5 years of that coverage for you and your wife, plus $3,000 of all the courses we have to offer, all the books we have to offer in every form we offer them. More details on all of that at lawofselfdefense.com/82cents. If you're not a platinum member, I'm not available for your legal case if you're involved in a use of force event. That's how we do it. We serve our platinum members only when it comes to legal consults. All right, folks. Until next time, perhaps tomorrow. I'm scheduled to testify this afternoon, but if they don't get me in this afternoon, it might be delayed until tomorrow morning, in which case there won't be a show in the morning tomorrow. Sorry about that. Obviously, I do these things at the pleasure of the court. So we'll see what happens. But until we meet again, which will be, I'm sure, very, very soon, remember, if you carry a gun so you're hard to kill, that's why I carry a gun, so I'm hard to kill, so my family is hard to kill, then you also owe it to yourself and your family to make sure you know the law, so you're also hard to convict. Until next time, I remain Attorney Andrew Branca for Law of Self-Defense. Stay safe.